Okay, thank you. Judge Alyssa Perez resuming the criminal docket for the 210th District Court, calling cause numbers 2021 0D00716 and 2022 0D00844, State of Texas versus Crystal Destiny Reyes. May I have announcements?
Roa King for the state of Texas.
Christopher Anchondo on behalf of Ms. Reyes. We are ready.
And Ms. Reyes is appearing from the jail annex. Ms. Reyes, I know we were originally scheduled for, I believe, bond hearings and a probation status hearing. I'm sorry, not probation status, 2 bond hearings. But your attorney, I believe we spoke with him this morning, went to see you, and I received plea paperwork. Is it your understanding you're here to plead today?
Yes, ma'am.
Okay, so I'm going to go ahead and get started with your plea. I'm going to need to swear you in. If you would please raise your right hand. You swear or affirm that any testimony you provide will be the truth and the whole truth.
Yes, Your Honor.
Thank you very much. Would you state your name and date of birth for the record, please?
Crystal Destiny Reyes, August 14th, 1999.
And as I mentioned, the plea is only with respect to cause number ending 0716, ma'am. You should have reviewed documents with your attorney, the first of which is marked as State's Exhibit number 1. Those are the plea papers. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Ms. Reyes, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, ma'am.
Did you understand everything contained within that document?
Yes, ma'am.
Mr. Anchondo, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor.
And did you explain the plea papers to your client?
I did.
Do you believe she has understood the admonishments, rights, and consequences of giving up these rights by entering her plea today?
I do.
Ms. Reyes, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Mr. Anchondo, any reason to believe your client is not presently competent to enter her plea?
None whatsoever, Your Honor.
Ms. Reyes, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who's found you mentally ill?
No, ma'am.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Ma'am, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
El Paso, Texas.
Okay, in this case, you were charged by indictment with a first-degree felony, that being manufacture or delivery of a controlled substance in penalty group 1 in an amount between 4 and 200 grams. To that charge, ma'am, what is your plea, guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
Yes.
I'll find you are making your plea freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element of the offense charged, manufacturing or delivering controlled substance, the penalty group 1 in an amount between 4 grams and 200 grams beyond a reasonable doubt. Your Honor, the defendant is pleading to 5 years straight probation and other terms and conditions of probation stated on the state's plea paperwork. And the state will dismiss cause number 2022 0D00844. And at this time, the state moves to admit Exhibit 1 as the state's plea paperwork, Exhibit 2, Article 3914 disclosure, and Exhibit 3 is the indictment.
No objection, Your Honor.
Without objection, states 1, 2, and 3 is admitted. And Mr. Anchondo, is that your understanding of the plea agreement?
Yes, it is.
And Ms. Reyes, is that your understanding of the plea agreement as well?
Yes, ma'am.
Okay, I understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm asking you about is the 1-page document entitled the Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Ma'am, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
Was signed by your attorney and signed by the court as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of manufacture or delivery of a controlled substance in penalty group 1 in an amount between 4 and 200 grams. And I will sentence you according to the plea agreement at 10 years confinement in the Texas Department of Criminal Justice Institutional Division that will be suspended, however, for a period of 5 years of community supervision. There will be a $2,000 fine. The entirety of that is probated, which means, ma'am, that you will not owe the fine as long as you are compliant on probation. If at any point you are not compliant on probation, they can come back and collect the entire fine. Drug offender education class, 300 hours of community service. Oh, I can't read my own writing. Urine and breath analysis, curfew. And I think I'm missing something there. I'm not sure, but all terms that were listed in the plea paperwork will be part of your conditions. There is also a dismissal I will sign once received in cause number 2022-0D00844. So as soon as I get that, we'll dismiss that one, Ms. Reyes. Was I missing something significant there, Ms. King, or Mr. Anchondo?
Just
No.
the tap. Oh, it was just a tap evaluation.
That's what it was. That's what I could. So they will also be screening you through TAP. So good luck to you, Ms. Reyes. As I mentioned, I'll assign the dismissal when I get it, okay? Thank you, Mr. Anchondo, for expediting this.
Thank you, Judge. May I be excused?
You may. Thank you. Okay, who's next?
Second on page 16, Judge.
Mhm.
Annex, may we have Cifuentes, Carlos Cifuentes?
Yes, sir.
Mr. Cifuentes, is that you? Okay, perfect. Go ahead, Mr. Middlepool.
In cause number 2022-0D01212, State of Texas versus Carlos Alberto Cifuentes. Announcement of council, please.
Roa King for the state of Texas.
Justin Underwood for Mr. Cifuentes. Good afternoon, Your Honor.
Good afternoon, and Mr. Cifuentes is appearing remotely from the jail annex. We're just scheduled for judges conference today. Everything tracking okay? We've got our trial in February.
I don't know that hello, Ms. King, how are you?
I'm good. How are you?
I'm good. I don't know that we have an offer from the state yet.
Not yet, Your Honor. We are still waiting for some testing to come back. The most recent one from DPS was firearms, and that was August 9th. And I just wanted to see if Mr. Underwood wanted to do any evidence review or after everything comes back.
As long as everything gets uploaded in portal, we check it periodically. We update our file so that I can keep Mr. Cifuentes updated via me and my staff and our investigator.
If we start to run into any issues, Mr. Underwood, on how quickly or not quickly these things are getting tested, I know you'll let us know via motion, and if you need a hearing, we'll get to a hearing. Okay?
Certainly, Judge, and I do understand that I know DPS is doing their best, so I understand that it's not because they're doing it on purpose at this point. I don't think anyone's doing anything to delay it intentionally. I understand. I have many cases, so I kind of understand what the delay is. I don't think it's being done on purpose, and I do think that they're trying to be as forthcoming with the material as it comes in, Judge.
The next setting is in October, is that 2801 setting. Obviously, if we still have a lot of things outstanding, which I think is likely, that'll be a flexible deadline. Okay.
Thank you, Judge. Yeah, the only thing I would ask, and I would ask obviously from the state, is if we're still pending testing and stuff, if we can, like the court mentioned, if we can maybe have a fluid 2801 date, so that way if there's something particular that I need to have re-examined or an expert looked at or something like that I'm unaware of at this point, that we can do that.
Absolutely. Okay, thank you, guys. Mr. Underwood, if
Yes,
you don't have anything else, we're good to go.
Not at all. Mr. Cifuentes, I will be out to chat with you myself very shortly, okay? Take care. Thanks, guys. Bye-bye.
Thank you. Y'all are excused. Who's next?
Page 14, Judge. Annex, may we have Castanon, Arturo?
Yes, sir.
So this one we were pending an update on, wasn't it a new case?
Yes, Judge, there's 2 or 3 new cases and one of them is aggravated assault with deadly weapon, and it's been pending for a few months now.
Okay, yeah, I don't see him, but let's go ahead and get started. Go ahead.
In cause number 2021-0D00306, State of Texas versus Arturo Castanon. Announcement of council, please.
Javier Salcedo, Assistant District Attorney for the state, ready to proceed.
Victor Serrano, on behalf of defendant, Your Honor, ready to proceed.
Okay, so I have 0306. I also have 2021 0D00628 and 2020 0D04353. None of which I believe are the cases we were hoping would be Right.
Yes, Judge.
So, and they're all set for bond hearings, correct?
That's correct, Judge. If the court can recall, we had a hearing back on the 22nd of June and again on the 9th. And the state had recommended, I think, modifying him to perhaps just take him BIP. And that's why the court wanted to come back in 2 weeks. But I do not have access to the DA portal. I've asked, requested 3 or 4 times already, and same notice, its case is inactive and you'll have access once it's activated. So I do not know the basis of the allegations for the revocation. But what we're considering, Judge, is requesting the court to allow him to perhaps go to some counseling, some drug counseling. He's been in there now since June the 1st. It's almost going to be 3 months. So that's why we're requesting the court to consider a bond in this case, in the 3 cases that we have.
So, Mr. Hernandez, if you would please, or whoever has it the most handy, Mr. Salcedo, send the motion to revoke via email to Mr. Serrano. My recollection on the bond hearing, Mr. Serrano, was not so much, it was more because DAs were going to look into how quickly we were getting these new cases. The new cases are really the issue. I can tell you just, I've got it pulled up now. The allegations are the new offenses and then some other technicals. Let's see, fails to report February through April. Carla, is this the one that had weekly reporting? I haven't gone back to the summary yet.
Yes, sir. Yes, ma'am.
Yes, Your Honor, weekly testing as well.
So I think there were some tests, but there were not other tests. And so let me go back to the bonds. Okay, so well, Marissa, if you will chat me what the bond amounts are, and then Mr. Salcedo, can you tell me where the new cases are?
Yes, ma'am. As to the new charge, it is an aggravated assault with a weapon. And that one occurred, and I'm trying to get it on here.
It looks like June 1st, at least that's what's on the motion to revoke.
That's May 30th of this year, June 1st. So it's about around the time. It's against the girlfriend/wife. The report indicates that the defendant, and we get to the actual affidavit, they get into an argument. He pushes her out of a car.
I remember.
He also, the complaining witness in this case has a dialysis tube located on her upper right chest that is used to administer medication. Allegation is that he tried to yank it off her body. Also that he pulled a handgun on her. And so we made a request to get the case presented to the grand jury. But they have not given me a time or a time frame as to when that's going to happen.
Okay.
And so just so the court knows, this is the same complaining witness from make sure it's the right one.
Is he on deferred on the probation cases?
I believe he's on straight, Judge.
It's straight, Your Honor.
Yeah, it's these new cases. Do we have a timetable? Do we know, or how quickly are we going to have or not have new cases?
Judge, I can ask the intake unit to get this presented to the grand jury by next week. And so I'm not sure how fast or if that's going to be feasible. We've been having issues with the grand jury where we don't have a quorum for the grand jury to proceed. So that's also been an issue that we've had. But I can certainly try to get it presented next week.
I'm pretty sure that's where we were at the last setting.
That's correct.
So there is, just so the court knows and Mr. Serrano know, we try to make contact with the complaining witness to let her know about the bond hearing that we had on that P file, we were not successful in getting in contact with her. She does have a protective order, and I think that's going to expire, I believe, in the next couple of days.
Yeah.
Yes, Judge, if you can recall, this is the same complaining witness that actually stabbed my client on the neck, and he was hospitalized for a few days. So I don't think she's gonna show up either. There might be a problem with that case, that she's nowhere to be found. She doesn't have an address or anything like that, Judge.
Well, no, she does have an address.
Mhm.
She does have an address. It's just that when we try to call her and try to locate her, she's not
Yeah.
responding.
Yep. And
So
that's,
the last incident we had with this complaining witness was back in 2021, and it was kind of the same thing, Judge. We couldn't get a hold of her.
mhm.
Okay, but so our new cases are the ag assault. Is that it? I thought there was a fraudulent use.
Yeah, I believe allegations of some sort of IDs, I believe, possession of some IDs, but we have no idea.
Mr. Salcedo, what's your position on the bond?
Judge, that would be my concern, the complaining witness in this case. He hasn't been cooperating with the probation department. He's not taking the probation seriously. So I will leave it up to the court to decide. But at this point, if we're able to file this ag assault with a weapon, even if it's a simple assault, we're going to be moving to revoke the probation.
Yeah, I agree. But we still need to know if we have new cases or not. Mr. Serrano, may I ask you, and then I see your client's got his hand raised. Don't speak yet, Mr. Castanon, okay? Just hold on. I see you raising your hand. Mr. Serrano.
Yes, Your Honor. As we previously stated, the aggravated assault deadly weapon, that one has been reduced from $75,000 to $35,000. The family is ready to make a bond amount. All that we need is for the court to grant us a bond on this on the cases are the probation cases. That's what we're waiting for, Judge. And as far as to my knowledge, Your Honor, Mr. Castanon hasn't had any contact whatsoever with the complaining witness in the aggravated assault with deadly weapon. Ever since, I think in June, and before that, Judge, I don't believe they had much communication. In this case, my understanding is that she's the one who called him, and so he went to pick her up, and that's how this whole thing started. I think they were separated for a while after the complaining witness stabbed Mr. Castanon. And so, but she's the one who again initiated contact with him after she stabbed him.
Mr. Salcedo, are you able to tell, I'm not sure if you're able to tell with the case not being indicted yet, did they recover a firearm?
I'm checking, Judge. Well, Judge, and if there was a weapon, I think they would have also been charged with unlawful possession of a firearm by a felon.
correct.
So I don't think that it was.
My understanding, Your Honor, is that the prior incident is DWI third or more, and of course, it's three drug-related offenses.
No, Judge, I don't have any access as to what evidence or property was obtained, but I'm going to go through the notes real quick and see if they have anything on here. But it was just her telling the officers that he had had a weapon with him.
I believe the report was made the next day, not on the day of the alleged incident. Am I right?
So, yeah. Unfortunately, Mr. Serrano, I'm not in agreement with reducing the bond. The ag assault at 35, it is what it is, but we will come back in 3 weeks. That I will tell you.
So no bond on the probation cases, Your Honor?
No, sir.
I understand, Your Honor. I will let
Okay.
him know.
That request is denied. I think, Myrna, what we need to do in 3 weeks is have it set for a pre-revo. And then 30 days after that, revocation hearing.
Okay.
And if we can make a notation to check with the state on the new cases. Mr. Castanon, I'm hesitant to ask you what you're going to say because your attorney's here and I don't know what you're going to say. If you need to talk to him, or if Mr. Serrano, if you need to talk to him, you'll have to wait to get a breakout room so I can take care of a few more cases.
Yes, Your Honor.
Is that okay? So I'm more than happy to bring you back, Mr. Castanon. I just don't want you saying anything that might jeopardize your situation here, okay? All right, we'll come back. If you want to go ahead and wait, Mr. Serrano, we'll have you wait.
I
Thank
will
you,
do so,
Mr.
Your Honor. Thank you.
Castanon. Thank you. Who's next?
Staying on page 14, Judge.
Mhm.
May I have Bautista Gilbert Annex?
Yes, sir. Bautista. Bautista.
All right, is that Mr. Bautista? Is that you? It's yours, Mr. Stevens?
Yes, Your Honor. Good afternoon.
Good afternoon. Go ahead.
In cause number 2020-0D00002, State of Texas versus Gilbert Bautista. Announcement of council, please.
Javier Salcedo, Assistant District Attorney for the state, ready to proceed.
Brent Stevens for Mr. Bautista. We're ready, Your Honor.
Okay, and we're scheduled today for a bond hearing. Mr. Stevens, you may proceed.
Your Honor, I had been emailing Ms. Pineda earlier today, and I CC'd Ms. King and Ms. Rago, but I failed to CC Mr. Salcedo, so I do not know if he's aware. The last time we were here, about 2 weeks ago, we had a bond hearing, and at that time, the court indicated you were wanting him to go to BHRTC. So I spoke to Mr. Bautista, and he agreed.
Mhm.
However, BHRTC is not accepting him, and I don't know the reason. It may be,
Oh, is this
it
the
may
one
be-
where, I'm sorry, I don't mean to interrupt. Is this one we just need an order, Carla? Is this the one we were discussing? Or is this a separate one? Why was BHRTC not accepting him?
This one, Your Honor, he was screened, but unfortunately, there is no, I guess, evidence, any proof that there is any substance abuse issues. Since he doesn't report, it's been hard to actually get a drug test going. He doesn't show up to drug tests. So there is no indication of any substance abuse. Although we can see the issues as per what Mr. Brent Stevens has mentioned in the past. This one, the last hearing, Your Honor, probation was going to try to screen him for MHI caseload, but there were, again, no indication that there was any mental health issues. So then you asked for BHRTC, but then here we are with BHRTC. The next step, Your Honor, I was letting Mr. Brent Stevens know is Ms. Alayendia, probation officer, was going to screen him for substance abuse caseload to see if that would work within the specialized caseload.
Okay, and through that screening, that wouldn't be sufficient. For example, if he was, based on that screening, eligible to be modified to substance abuse caseload, that wouldn't suffice to indicate he would also be eligible for BHRTC. Like if they're documenting there, that's not enough for BHRTC.
I would think so, Judge. But again, it's up to the court's discretion. If BHRTC would be ordered, we could modify him to BHRTC, Your Honor.
So let's, since basically, I guess we're just talking about it, let's get him screened in terms of getting him on that substance abuse caseload. But once he is screened, I want to come back and revisit. And I'm thinking it's BHRTC unless there's some benefit to just going that route. I mean, if all we're saying is we're missing the evidence that he has a problem requiring BHRTC, if we screen him for that, I mean, it seems kind of ridiculous to have to go through those.
Your Honor, and I do want to, if I may add, he was screened, and as far as he was recommended for outpatient services, so And he is recommended to take some kind of treatment.
Judge, we would be in agreement with going on to the substance abuse caseload or an equivalent modification, you know, even if he's not in that caseload. My question though is, I mean, he's being held right now with no bond. And if he's going to be screened for the substance abuse caseload, I mean, we're in agreement with that. I would ask that he be released and put on equivalent modifications in the meantime. And then later, if the court determines based on whatever happens that that you think he needs to go to BHRTC, then we could revisit that.
Oh, so probation's recommendation is that. Yeah. What, does the state have any input here?
I hope I have a little bit of input, Judge. He's not, he hasn't reported. He was placed on probation, and from July to August, didn't report to probation. He's not doing curfew, not doing what he's supposed to be doing or has been asked by the court. We don't know if he's using or not because he hasn't submitted to drug testing. And so I would echo the same thing, that he be screened while he's detained, and depending on what happens, then send him to BHRTC. I think he has to be detained to be sent to BHRTC. He cannot be out and about. So if he does qualify, he's detained, they can send him right away. If he doesn't, then I would ask that the courts give him some type of jail sanction, and then maybe modify him to some type of either mental health caseload, drug treatment caseload, something like that as an alternative.
Okay, let's get him screened then for that substance abuse caseload. Yeah, I'm looking at this one. When did he plead? Back in 2020.
Your Honor, and if I may add, the email was already submitted to Ms. Caro, who is the Director of Special Programs, who formalizes and finalizes, on the screening. We're just pending her response, so I'm pretty sure we'll get some kind of response. I'm not sure if the court would consider resetting this for 1 week minimum.
And we've already done a jail commitment. I mean, does he really want to be on probation, Mr. Stevens?
Well, I mean, no one wants to be on probation, but I mean, the alternative in this case is not good. So I would like to give him the opportunity to succeed. He wants to succeed. I mean, he realizes that he's got a problem. So I know he wants to succeed. He has, you know, work waiting for him once he's released, but
all right. Okay. We're going to come back in Holly. We're going to come back in 3 weeks. 3 weeks, and we'll see what's going on with the screening. I see here, I missed that, Carla, where it says that he met criteria for outpatient services. I'm not sure I'm there. And I think Mr. Salcedo is probably right. We might need to look at some other sanction, but let's go with that for now, if that's what we're talking about, is some treatment. Okay.
all right, Judge. Well, we'll follow up ASAP then. Thank you.
Okay. And just with respect to, I mean, we were set for a bond hearing. You're not going forward on your bond reduction?
I will ask, yes, Judge. I mean, I'll go forward with the hearing if you'll consider it, but it didn't sound like you were even going to, that he has much of a chance. But I mean, my client is 25. He's on deferred for robbery. He's a U.S. citizen. He's been in El Paso his whole life, with the exception he was in Odessa for a short time. If he's released, he will live with the mother of his soon-to-be child. He has a work waiting for him through her business.
I remember. Mm-hmm.
So I don't have evidence of any kind of mental health, but I mean, I do think he needs to go through TAP. Okay. And cooperate with it.
Okay. I do remember Mr. Bautista, the original case as them. Okay, so he's on deferred, Mr. Salcedo. He's entitled to a bond.
Yes, Judge, I would ask that he not be given a full PR bond. The court set a bond that's fair and reasonable given the circumstances. He has not reported for almost a year, and he didn't turn himself in. He was initially arrested, so he doesn't show us that he is willing to do probation. I do feel that he does have a family and he's got a job, but this should be his priority, reporting to probation. And he doesn't seem like he's taking it seriously. So we would ask that the court set a bond that's reasonable to ensure that he is that he returns to the court.
And I think Mr. Salcedo hit the nail on the head. I think that's been our issue before. The bond he's entitled to one will be set at 75,000 cash surety. Okay,
Thank you, Judge.
thank you very much. Who's next?
Judge, you mentioned that he had a jail sanction. I didn't see a jail sanction.
It was in the case summary.
Was it for
And it
15
might
days?
have been, it might have been right when we were going back and forth with the whole, he was in Odessa, that kind of thing. And then we really went off track. So.
Okay,
Thank you.
thank you.
Okay, who's next?
Bottom of page 16, Judge, the add-on. Annex, may we have Mills, Philip Mills?
So did we get this taken care of so that he is appearing as you all have requested, Ms. Bayan? Yes?
Yes, ma'am. Yes, ma'am. I worked with the annex personnel last week, and Mr. Driscoll is there at the annex with Mr. Mills. Thank you.
Okay. Good afternoon, Mr. Mills, Mr. Driscoll. Okay, let's go ahead and call it, please. Did we already call it?
No,
No,
ma'am.
Judge, I haven't. In cause number 2021-0D02641, State of Texas versus Philip Daniel Mills. Announcement of council, please.
Well, okay, for the state of Texas, state is ready, Your Honor.
Edith Payan and George Driscoll on behalf of Mr. Mills, and we are ready, Your Honor.
And Mr. Mills is appearing remotely from the jail annex. Mr. Driscoll is physically present with him there at the annex. This was a reset from yesterday. I think we were still set for a status. I'll have to go back and look, but I do now see that there is a motion, an agreed motion for continuance, which we also discussed at the last hearing. So this was meant to be an update on some of the discovery, if I'm not mistaken. Ms. King, did you have an update?
Yes, Your Honor. So as far as the evaluation by Dr. Proctor, that is, I did convey the dates with Ms. Payan, I believe last week, and that's actually for November 22nd of 2022 for the state to have him evaluated. As far as, Your Honor, do you want me to go kind of in the list or pause after?
I'll just ask Ms. Bayan if there's something you need to interject. Let's do it kind of by subject matter. Ms. Bayan, did you want to address that now?
No, Your Honor.
Okay. All right, go ahead.
Your Honor, and Ms. Bayan did inquire about an email that was mentioned in a lab report dated June 24th. It was in the correspondence between what's stated on the report as a customer and DPS. She did ask for a copy of that email. That email has been uploaded to portal. Ms. Bayan also inquired about 2 Miranda cards to be uploaded on portal. One Miranda card was by the fire department at the scene at the time of the incident. There's already an audio of that for the Miranda that was given. That's on portal, but now the actual Miranda card has been disclosed to Ms. Payan and it's on portal. As far as the Miranda card that was signed by CAP, Detective Lara, I am still inquiring on that. I did let Ms. Bayan know that Detective Lara is no longer with CAP. So he is taking a minute to kind of reply back. But I will keep Ms. Bayan updated. There is also, Ms. Bayan did ask for a copy of the FARO that was done. I did have that FARO disclosed, and I believe she did have her office pick it up. Also, we did discuss the trial dates and the motion to suppress dates as well, and I believe she put that on the motion, that great motion for continuance. Also, there was a submission form for one of the evidence by crime scene officer Valenzuela. That's been also uploaded on portal. Also, the entire record that was disclosed, and I believe her office also picked it up, that the full report filed by the fire department, that was whatever hard copy I was given by the fire department was disclosed to Ms. Bayan, and also they did contain the entire file in a USB. That's just all the only thing that is outstanding, Your Honor, is that Miranda card, and also to see when all the items will be back so we can set up an evidence review.
All right. Okay, before we get to anything on the motion for continuance, Ms. Bayan?
Your Honor, yes, I'd like to point out that Ms. King and I, the state's been very cooperative. We had 2 meetings last week to sort through this, and we did receive a USB yesterday. I have not had a chance to talk to the state about it, and I do need to work with my office or maybe ITD to some of these folders. They don't open with my computer, so I'll continue to work on that. If there's any issues, I'll work with the state. And yes, except with the discussion regarding the trial dates, there is still the physical evidence that was sent to be tested. And I now understand the fire department sent evidence, as did the El Paso Police Department separately, but Ms. King is working with both entities and DPS, and once everything is back, so we can go look at the physical evidence as we need to with our experts.
Okay.
Your Honor, if I may, everything that the state submitted for testing with DPS has been tested, and all the reports have been uploaded on portal. And so we're just kind of waiting to, there was 4 physical items that were submitted by crime scene unit to DPS for testing. However, we have the ones that were submitted by the fire department, and if I recall, it would be a total of 8 items. So I'm trying to see how we can have everything in one place at the time of the evidence review.
I seem to remember from the last hearing that we were also, and I'm just going to ask if you all are kind of on the same page here, this idea, of having, making sure, for example, the state has mentioned, okay, we have 8 items, either, I think I heard completely, they have been tested, but I don't know if the defense is making requests for the state to test additional items. If you all have gone through kind of an exhaustive list of things at this point, or if that's still forthcoming, is there, or I just want to make sure both of you are on the same page there in terms of if there are things that still need to be sent out and kind of in an ongoing way, that is continuing to happen so that we don't have anything delayed.
Your Honor, based on the state representation that they've done the testing they need, and now that we've gotten these other reports, some I think were dated about August 11th, and now that I know what is done and not done in a portal, I will be meeting with our expert and see what he counsels us or what he believes we need to do. I would, like at least a couple of weeks on that. And at any rate, it would need to come back.
Okay. So I mean, basically, it sounds like, we're moving some, but I'm just trying to put this into context with the motion for continuance and looking at the calendar. So, okay, looks like he is already specially set. Yes.
Your Honor,
Mhm.
where we last left off, you had entered settings in Odyssey for February and March with the pattern to
Mhm.
for dire Thursday, Friday. In our agreed motion to continue, we gave the February dates, but went into April as our expert is not available during the March time period.
Okay, great. Well, thank you for double checking on that. So, okay. So here's what we're gonna do with our scheduling. Myrna, will you please look at April 20th and 21st just to make sure I don't have something else specially set kind of.
I
like
checked
this?
it. There's a few jury trials, but nothing specially set.
Okay, so we'll change that March, for sure, March trial dates from March 10th and the final hearing plea deadline March 7th, but we need to make sure we do the 2 dates. So it would be the 20th and the 21st. So we need to request those panels accordingly. So I see for that February trial date, we need to add the 9th because I don't see it there. So February 7th, 9th, and 10th, cancel March 7th and 10th. But I want to backtrack. The evaluation, you said November 2nd. Is that what you said, Ms. King?
November 20th.
November 20th. Okay. So we're going to cancel the October 4th setting unless somebody needs it.
October 4th for the final, it was a final pretrial, I believe.
It was a final hearing plea deadline.
Judge, may I ask that we keep it as just as a status in case, and we could work with the court a few days before and let you know if it should be canceled?
So if we do, then I want to change that because that's going to be a Tuesday morning. So it would need to be October 3rd. And I would prefer that we handle it in person in the courtroom. So let's do October 3rd at 10 a.m. We'll arrange for transport and we'll do it in person. And that will just be a judge's conference.
Thank you.
Then I want to do the same thing for December 5th. Again, a judge's conference. I kind of just want to reserve dates for you all to periodically check in. And that'll be the same thing, same time on a Monday in person. And then after that, I'm just going to go straight to that final hearing plea deadline in February. I will rely on you all if you need hearings outside of that to file any pleadings and request your hearings. We can also,
if I may, for now, we did file our motions to suppress, so we will need that hearing. In the agreed motion for continuance and in my discussions with the state, we had proposed, and obviously I'm in no means mean to think I know anything about your court's calendar or control it, but we were suggesting January 23rd. If Dr. Proctor is going to see Mr. Mills on November 22nd, with the 30 days to write the report, that's December 22nd, that puts us in Christmas, and then we have MLK. So that was just a suggested date. I do know we will need to litigate those matters. Additionally, I do predict if we do end up in jury trial, there will be some other motions that will need to be filed and ruled on without going into too much detail. But for example, there are some motions regarding voir dire. There's some motions regarding the constitutionality of the statute, and it shouldn't take long to get rulings on those. But for now, we did file the motions to suppress, and we will need a hearing on those.
And so you all are agreed on that date. The court's calendar is workable, so we'll do that as well. So add the January 23rd for a motion to suppress. I will say, if you have additional motions, I know we're looking further down, but just make sure for any of those dates, if there's something you need heard on those dates, either for the judges conference or for the date of the motion to suppress, please let us know ahead of time, so we can all be on the same page and everybody's ready to go on whatever's outstanding.
I think, Judge, it's just the balance for me and the state, and I would think the court, is not wasting time too soon, depending on what Dr. Proctor says, but then not having everything at the last minute. So again, once Dr. Proctor evaluates our client, we'll know much more about what we need to be doing.
Okay, and I agree. I was just checking the week before. Yeah, we don't have anything specially set. So yeah, January, let's secure it. January 23rd for the motion to suppress, and whatever else needed at that time. Same thing in person. I prefer to do them in person. What else?
I believe that's all, Judge. Like I said, the state's been very accessible, and so is the court. So, I mean, we're trying to keep ahead of things as they come up. So hopefully we'll get through this.
Well, thank you all for your work. We'll see you at the next setting. Thank you, Mr. Mills. Thank you, Mr. Driscoll. All right. Who's next?
Bottom of page 13, Judge. Annex, may we have Andrade, David Andrade?
Uh-oh. Carla, is there a case summary for Andrade? Or maybe Mr. Macias said it? I mean, I remember, but.
I emailed it late, Judge, not with the group.
Oh, okay. Oh, there it is.
Okay.
I see it now. Oh, here's the modification. Oh, okay. Go ahead, Mr. Marufa.
Cause number 2021-0D0-2386, State of Texas versus David Andrade. Announcement of council, please.
Javier Salcedo, Assistant District Attorney for the state, ready to proceed.
And Myrna Pages for Mr. David Andrade, ready, Your Honor.
And Mr. Andrade is appearing from the jail annex. As mentioned, I guess he's been accepted to BHRTC. Did he have a new case? Didn't he have a new family violence?
That's correct, Judge. He has 3 pending cases: assault, family violence, interference with emergency, request for assistance, and a criminal mischief that all happened June 25th of this year.
Okay.
Judge, and I did get a non-prosecution statement. I don't know if the state has communicated with the complainant, but it's my understanding she does not want to go forward with those charges.
So is he on, is he being held on those cases? Because we can't get him to BHRTC, if he has bonds, unless he's PR bonded.
Yes, Your Honor, that is correct.
Your Honor, I think he had pure bonds on all those cases.
Miss Mooney, do you see that on those misdemeanor cases? I keep saying Marissa and I forgot. It's kind of Marissa, but not really. If he is, then I think we're good to go, but
on the PR, he's only being held on the probation cases.
Okay, so he has PR bonds on all the misdemeanors. All right, then I'm good to just modify him to BHRTC.
Thank you, Judge. He's willing to work the program. So.
Okay, good luck to you, Mr. Andrade. Thank you, Mr. Macias. I know you worked really hard on this one.
Your Honor, if I could please request from the court a order releasing to the center. I did send over the modifications. I've already sent over the consent form, which Mr. Andrade did sign to the CLL. I just need the mod sign and the release order to BHRTC.
So I'll request that from the, I guess from the clerk. I think that's who usually gets it to me.
Yes.
Yeah. I'm signing the mods as we speak, Mr. Macias.
Renee.
Okay,
Thank you, Your Honor.
all right. Thank you very
And
much.
Judge, I'll be
Monday.
submitting the state's motion to dismiss the rebels that we have.
Fabulous, fabulous. Thank you, gentlemen. Thank you, Mr. Macias.
Thank you, Your Honor.
Good luck to you, Mr. Andrade. Take care. All right, desktop. Okay. Who do I keep hearing?
Martinez, is that Martinez?
I think that's the annex, Judge.
Okay, reply all.
Hey, I want to.
Monday.
I need to let you know, there's a Mr. Martinez that's in Odyssey, and the court sitting is available, and he's just not showing in our docket. I don't know what happened.
Who is this?
It's cause number 2021 0D0 1222. Mr. Dakota's on the case, and the gentleman's name is Michael Martinez.
Hey, okay.
I have no idea what may have happened. It's on the system, but he didn't print on the docket.
Okay, okay. Wow, my email is really filling up. Okay. So, if he didn't print on the docket, does the annex have him? Did we have notice to the annex to get him here?
Judge, Mr. Decote's office called and said they're willing to have the hearing. I called the annex and they're willing to work with us and bring him up front if we need him.
Okay, what is it, a bond hearing?
It's a bond hearing and a probation hearing status, Judge.
Okay, well, we'll leave that one for last. Who else do we have outstanding?
On page 14, Judge. Annex, we have Monroy,
Lieutenant, may I help you?
Eduardo Monroy.
Yes.
Monroy. Okay, regular bond. Mr. Monroy, is that you?
Yes, ma'am.
All right. Okay, go ahead, Mr. Marujo.
In cause number 2022 0D01043, State of Texas versus Eduardo Monroy. Announcement of council, please.
Roa King for the state of Texas.
And Myrna Pages for Mr. Eduardo Monroy. Ready, Your Honor.
And Mr. Monroy is appearing remotely from the jail annex scheduled for a bond hearing. Ms. Pages, you may proceed.
Thank you, Your Honor. My client, Judge, is only 19 years old. He's been in custody for about 45 days already, and he cannot make this bond. I believe that the bond on this case is 100,000 cash surety. We are asking for the court respectfully to reduce it anywhere from 10 to 20,000, Judge. My client is a U.S. citizen. He was born and raised here in El Paso. He does have ties to this community, Judge. If released, he would reside with his mother. Her name is Zenaida Monroy, and he would live at 3301 Lincoln here in El Paso. He does have family, Judge. He has, aside from his mother, his stepfather, as well as 2 older brothers. His mother, Judge, is his guardian, has guardianship over him, and has guardianship over any legal and medical decisions over him. Prior to being arrested, Judge, it was my understanding that he was working at a bread factory on Cotton Street. My client does have history of mental health, Judge, and let me pull up my form here. He has been diagnosed with major depressive disorder, which is recurrent, and general anxiety disorder. He was also diagnosed there at the jail, and he's currently taking medications. Per records, he does take Prozac, Seroquel, and Visceral. In addition, Judge, he does have an outside provider. He normally does get services at Project Vida. His doctor is Dr. Frank Meisner, who regularly sees him, and he does take medications there with Project Vida. And he is willing, if released, Judge, or given a lower bond, willing to continue treatment there. My client has actually been in different types of counseling since he was young, Judge, since about the age of 7 to 15 years of age. So he does agree that he would continue to resume services with Project Vida to address any mental health needs. He would also try to obtain employment. He does currently receive SSI as per his mom, and client would like to start services with the Texas Workforce Commission and also to obtain a GED, Judge. So we are respectfully asking for a reduction. I don't believe that the state has had any contact with the complainant. I may be wrong on that, but we would agree with no contact with the complainant, Judge. We are just asking for his bond to be reduced at this point.
So it's at, well, at least a portion of it is at 100,000 because it was a PR violation, right? And the PR violation was for picking up the POM unlawful carrying. Is that right?
That's correct, Judge. And I believe that let me look here. I don't think that these have been filed as of yet, Judge. It was a POM less than 2 ounces and unlawful carrying that has not been filed. And then he also had some old cases that were in a P-file state, a burglary of vehicle where Mr. Fernie Chacon is appointed on that. And that also has not been filed from, I believe, 2000, year 2000.
Okay. All right. Anything else, Ms. Pages?
Nothing further, Your Honor. Thank you so much.
Ms. King?
Your Honor, the state respectfully opposes the bond reduction. The criminal history, we do have a assault in 2018, juvenile assault causes bodily injury. The defendant was placed on probation and then was terminated where he pled true. The unlawful carrying of a weapon, date of incident, May 21st, that is still pending, and I have followed up with intake. There is the complaint. We have not had contact with the complaining witness. We attempted to reach her through the number that we do have. The number says it's not in service. However, it is the same complaining witness on, let's see, the misdemeanor assault causes bodily injury, family member. The date of incident for that one is March 1st, 2022. There is also a pending unlawful restraint and misdemeanors. Therefore, the state respectfully opposes bond reduction.
Let me see something. His original bond here was what? Was it the 5,000? Let me go back.
I believe in JMAG, Judge, back in March, they gave it was a 30,000 split bond. It was 10,000 cash surety and then a 5,000 PR component.
March 29th, so it had a $5,000 PR. Yeah. Right. So, continuous was split. It was 15,000 split 10-5 on March 29. Let's see this. The first one was 30,000 split 25 and 5, and it goes down again and it doesn't comply. So I'll go ahead and grant the request to reduce the bond, but I'm not going to reduce it a lot. I mean, he's had a couple of shots on bond and doesn't really look like he's being compliant. So I'm going to reduce it to a $50,000 split bond, 40,000 cash surety, $10,000 PR. He's to report once a month to the PR bond office. No contact with the complainant. I don't know when the outstanding, well, no, I'll leave those alone. No contact with the complainant, must remain 200 yards from her place of residence or place of employment, subject to testing, may not use alcohol or illegal drug, commit no new offenses, maintain his place of residence, and may not leave El Paso County without court permission. He is also to possess no weapons. Let's see. Yeah, that'll be the order. Any other conditions I missed there, Ms. King? Anything that? Yeah. Okay.
No.
All right. That'll be the order.
Judge?
Monday.
What is the reporting?
Once a month?
Once a month. Okay, thank you.
Thank you. Okay.
Thank you,
Anything? All right. Thank you very much. All right. Who's next?
Annex, may we have Monroy and Murphy, Michael Ray Murphy?
Are these all yours, Myrna?
Yes.
Mr. Murphy, is that you?
Yes, ma'am.
Okay. Let's go ahead and get started.
In cause number 2022-0D01549, State of Texas versus Michael Ray Murphy. Announcement of council, please.
Boa King for the state of Texas.
And Myrna Pages for Mr. Michael Murphy. Ready, Your Honor.
And just so I'm clear, can't tell from my notes. Is he pleading to both counts?
Yes, Judge.
Okay.
Yes.
Alrighty. Mr. Murphy, we are scheduled for a plea in this case today, so I'm going to be asking you some questions, which means I need to swear you in. Would you raise your right hand, please? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Would you state your name and date of birth for the record?
Michael Ray Murphy, date of birth 04/19/1995.
Mr. Murphy, as I mentioned, we're scheduled for pleas in this case. I'm going to ask you about documents, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Murphy, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, ma'am.
Did you understand everything contained within that document?
Yes, ma'am.
Ms. Pages, have you had more than 10 days to prepare a defense in this case?
Yes, Judge.
And did you explain the plea papers to your client?
I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
I do.
Mr. Murphy, are you satisfied with your attorney's representation of you?
Yes, ma'am, I am.
Ms. Pages, any reason to believe that your client is not presently competent to enter his pleas?
I don't have any reason, Judge.
Mr. Murphy, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who's found you mentally ill?
No, ma'am.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas. So are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Tulare, California.
Okay. In this case, you were charged by indictment with 2 counts. The first count is aggravated assault with a deadly weapon. Sir, that is a 2nd-degree felony. To that charge, what is your plea, guilty or not guilty?
Guilty, Your Honor.
And in count 2, assault, family violence, impeding the breath or circulation, that's a 3rd-degree felony. To that charge, what is your plea, guilty or not guilty?
Guilty, Your Honor.
Are you making each of your pleas freely and voluntarily?
Yes, ma'am.
I will find you are making your pleas freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element and count of the offense charge. Count 1, aggravated assault with a deadly weapon, and count 2 of assault family or household member impeding breath or circulation beyond a reasonable doubt. Your Honor, the defendant is pleading to 7 years of deferred probation. Further, there will be a deadly weapon findings, family violence findings, and no possession of weapon while on probation, and other terms and conditions stated on the plea paperwork. And at this time, the state moves to admit Exhibit 1 is the state's plea paperwork, Exhibit 2, Article 3914 disclosure, and Exhibit 3 is the indictment.
Any objection?
No objection, Your Honor, but I just want to make sure that we did agree to reduce his community service hours from 300 to 100. So I just want to make sure that that is part of the record.
I notated that. I already saw it on the plea paperwork, Ms. King. That was the agreement?
Yes, Your Honor.
Okay. So if there's no objection, states exhibits 1, 2, and 3 are admitted. And Mr. Murphy, is that your understanding of the plea agreement?
Yes, ma'am.
Okay. Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled the Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargain or negotiated case, you do not have an automatic right of appeal. Mr. Murphy, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
It was signed by your attorney and signed by the court as well. Finally, the motion for deferred adjudication. Mr. Murphy, do you recall reviewing the motion for deferred adjudication with your attorney and signing it?
Yes, ma'am.
Ms. Pages, have you explained to your client both the benefits and detriments of deferred adjudication?
I have, Judge.
Mr. Murphy, do you understand that if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment in this case? Do you understand that?
Yes, ma'am.
And are you asking the court to grant you deferred adjudication?
Yes, ma'am.
Okay. I will find there is sufficient evidence to substantiate findings of guilt. However, I will not enter findings of guilt at this time. Instead, I will defer further proceedings and place you on community supervision pursuant to the plea agreement for a period of 7 years. There will be a $3,000 fine. However, the entire fine will be probated, which means as long as you are in compliance with your probation, you will not owe that fine. If you are not in compliance, they can come collect the entire $3,000. There are 100 hours of community service, court costs, urine and breath analysis, curfew, deadly weapon finding, and family violence finding. In these cases, you're to attend anger management, you're to have no contact with the complaining witness, and you may not possess any weapons while you're on probation. Is there anything further, Ms. King or Ms. Pages?
Nothing further from the state.
Yes, Judge, there are two issues that I would like to address with the court. Number one, my client would like to transfer to California, Judge. His mother lives out there. I believe he has a support system out in California. And so I have explained that to him. I have explained that he would have to be accepted and he couldn't leave until that happens. Mm-hmm. But I do want to let the court know because he does wish to do that. Mm-hmm. And also, Judge, there is part of the plea agreement, no contact with the complainant. My client does have children with the complainant. I don't know if the court would be willing to put no offensive contact, just because there are, children involved. Obviously, he is the father of them. And so we are asking for that, Judge.
Is there, let me ask, I'm not sure about date of offense here, but is there an active protective order? What I'll say is this, well, let me ask Ms. King, any issue on switching from no contact to no offensive contact?
No, Your Honor, I do. When I spoke to the complaining witness, she was telling me that they do have kids together, and I believe they are actually going through the child custody, child support. Okay. There was no indication that the state would find any problems with having no offensive contact.
Okay, so I'm going to go ahead and change that to no offensive contact, but I will have the little caveat there that probation check to see if there is any type of protective order. If there is a protective order that kind of supersedes or is more stringent in terms of the conditions, you will be required to follow all the conditions in the protective order. Okay, as long as it's in effect. But I don't have a problem with no offensive contact. So with that said, and with respect to the transfer, Mr. Murphy, your attorney is absolutely right. There's a process. I have no problem with you going where maybe you can kind of move on in a better manner and with a better support system, but there is a process. So you'll get with probation to get that process started, and California will have to accept you. Once they do, then you'll be good to go. Okay. Any issues, come back to the court.
No.
Thank you very much. Ms. Pages, anything else?
Nothing further, Your Honor.
Good luck to you, Mr. Murphy.
Thank you, Your Honor.
Welcome. Who's next?
Up page 16, Judge. Annex, may we have Romero?
So was I really at BHRTC on Mr. Romero, or were you all at BHRTC and I wasn't?
You gave us 2 offers last time, Judge, BHRTC and 2 years TDC. I have talked to my client and he is opting for the 2 years TDC, Judge. And we did get the steps and waivers from Ms. King, so I just need to meet with my client and get that filled out.
Okay, so I'll reset you for 3 weeks as well, because I think next week we're already kind of piling it up. So we'll reset this for 3 weeks for another pre-revo, anticipating that it'll be a plea of true in some manner. If there are any issues, Ms. Pages, then we'll go ahead and schedule it from there. Okay.
Okay, sounds good, Judge. Thank you.
Thank you very much. Thank you, Mr. Romero. Your attorney is going to go see you. Okay. So do we have Mr. Dakotes and possibly his client? If not, I don't want to really put that on the agenda.
Mr. Dakotes is here.
I'm here, Judge.
Alex, did we give Mr. Martinez, Michael Martinez?
Martinez.
I guess something happened, Your Honor.
So yeah,
But,
Myrna
it's been
was
fun
telling
being
me
here.
it was said, but for some reason didn't come out on the docket. So I don't know what that's about.
Super weird. Yeah.
What is it set for, bond hearing?
Yeah, Judge, pretty much. I just kind of want to address you about a few things.
Let me get a cause number real quick. Let me put that into
Sure.
Into Odyssey. Go ahead.
2021-0D0-1222, State of Texas versus Michael Allen Martinez. Announcement of counsel, please.
Roa King for the state of Texas.
Oh, the codes for Michael Martinez, ready, Your Honor.
Okay, and Mr. Martinez is appearing remotely from the jail annex. It looks like we're set for both a bond hearing and a probation status hearing. Mr. Marufo,
Yes,
if you're able to, can you please run the PSR on Mr. Martinez?
It's ready, Judge.
Okay, thank you. All right, go ahead, Mr. Dakotes.
Thanks, Judge. Just real quick, I remember this gentleman and I remember thinking, didn't we just plead him out? And I guess in February through May, he neglected to do what he was supposed to do. Thank gosh, no new offenses, but failed to report, failed to pay, et cetera, et cetera. Now, what I remember about this gentleman is that he was a nurse or is a nurse. And it's like, man, well, that's odd. I hate to hear that. So I don't mind if you want me to ask him what's going on, if Your Honor wants to ask him what's going on. And I'm hoping that we can continue on probation and he needs to take the court and his probation seriously. Thank you for your time, Your Honor.
Okay, so before we go to that, Ms. Carla, I know this is kind of, I don't know how quickly we generate those case summaries. Oh, poor Ms. Carla, but I don't think I have it. Or do I already have it? Oh, there it is. I see it. Sorry to interrupt your phone call.
It's okay, Judge. I'll call the annex back.
So many emails during this window. Okay, so he was placed on deferred on February. He just never reported. Well, okay, that's not good. Let me go to the PSR. Okay, well, we're set for a bond hearing. Ms. King, you want to address the bond?
Yes, I don't see any new offenses. However, as stated, he was placed on probation February 2022. I do see, yeah, he was an absconder. He never reported for February, March, and April. And I believe that the address he did provide to his CSO was, I believe it came back to a church and not a home address or a shelter of any sort. Your Honor, is just that, the minute he was placed on probation, and he absconded.
Yeah, you know, he should have done more, Judge. If you want, I can do kind of a question and answer with him and not really get into it too much.
Well, I'm
But
gonna swear him in if that's what you're gonna do, Mr.
Yeah.
DeCote. Okay,
we might be able to skip things and just do that. Yeah.
Mr. Martinez, your attorney wants to ask you some questions for the court to consider with respect to your bond. So I need to swear you in. If you'll raise your right hand, please. You swear or affirm that any testimony you provide will be the truth and the whole truth.
Yes, Your Honor.
Thank you. You may proceed, Mr. DeCote.
Thanks, Judge. So, Michael, without saying that you didn't go and see your PO and without saying that you didn't pay fees, what's going on in your life? Because I remember you were a nurse and then all of a sudden you don't have an address and you look a little different now. What's up? What happened?
When I got out, the place that I was supposed to be staying at was not what I was told it was going to be. I do currently have a residence. I do currently have a phone number. So
all right. Can you follow what the state and the court wants you to do, or you're just not capable of that?
Yes, I'm able to. When I left, I was told that they would contact me.
Okay, and I can ask the court or the state, but you probably know better than anyone. How long have you been in?
Right now, this time?
Yeah.
Yeah, almost 2 months. About a month.
Okay.
Maybe a month and a half.
That's about all I have, Judge. We're really hoping for another chance, either a bond or whatever you guys think.
So the recommendation from probation is to increase reporting to biweekly reporting, including 1 in-person, and complete 2 UAs within 24 hours notice. So, but he did miss 3 months. So
Yeah.
he's been in how many days?
He's been in, he says 2 months. I don't know the exact days, Your Honor, but you know, that's a pretty good whack on the hand.
He's been in 30 days, Your Honor.
30 days.
Oh.
Yeah, so we're gonna do, he's yeah,
If you want to revisit, Judge, whatever.
no, I don't want to revisit. What I'm gonna do is I'm gonna give him a 90-day jail commitment and modify him as recommended by probation. So bi-weekly reporting, and one of them has to be in person, and you're going to be tested, have two tests per month within 24 hours notice. Really, Mr. Martinez? Go ahead, Mr. DeCote.
No, I just wanted to thank you, but go ahead, Judge.
No, this is a slap on the wrist. You basically pled and then just decided to chuck it all. So you should be facing rebel. What is he on for? A drug case, right?
Yes, Your Honor. Possession, controlled substance, I think.
4 to 200?
Something like that.
Yeah, 90 days sounds right. So he's gonna stay in jail, and once he's out, he will be modified accordingly. His conditions will be modified accordingly. So I don't know if you need to talk to, well, yeah, you don't need to talk to him. That's
I'm gonna go talk to him, Judge, but we appreciate your mercy. Thank you very much.
All right, thank
Your
you.
Honor.
Monday.
I apologize to interrupt, but I'm not sure if on the record I can have Mr. Martinez provide us with an address, since I am the one that speaks to them.
I don't mind.
The last time he did provide me with the address and phone number that we had in file, and that was inaccurate. So I'm not sure if he can provide us with something current.
So you're still under oath, Mr. Martinez. What's your address?
It is 5775 Sean Haggerty Drive, Unit B.
Sir, do you have a phone number?
Yeah, I'm gonna give you two, one for me and one for the person I live with. Mine is 915-499-0638. And another one that could be contacted is 915-637-8755. And she has actually emailed who would be my probation officer since I've been inside the county jail. Her name would be Bernice Becerra.
Got it. Thank you.
Anything else, Carla?
No, Your Honor, but that way I have it on record. Thank you.
Okay, sounds good. Thank you, Mr. Martinez.
You're welcome.
I
Thank you.
think that's the last one, right? So we can get back to Mr. Castanon. Thank you, Mr. Coates. You're excused.
Thanks, Judge. Thanks, Roa. I'll talk to you soon, Michael. Bye.
Okay.